Protection of migrant workers' rights in bilateral labour agreements. A major reason why countries of origin enter into bilateral labour agreements is to ensure better protection of their workers in destination countries. For this to be effective, there are two requirements. First, there must be provisions in the agreements that clearly spell out the protections afforded to migrant workers. Second, the bilateral labour agreements must be effectively implemented and monitored. Bilateral labour agreements should be designed to reflect a clear commitment to international human rights instruments and labour standards for the protection of migrant workers. They can pledge to protect the rights of migrant workers through equal treatment and non-discrimination, and include gender-specific and rights-based provisions. Fair recruitment principles can be included in bilateral agreements to ensure that workers receive free, full and accurate information on overseas employment, and they do not pay recruitment and placement fees, and to guarantee as well that their rights are respected and protected throughout the migration process. Bilateral labour agreements can commit signatory countries to provide needed assistance to migrant workers and to brief them fully prior to departure on their rights and obligations, working and living conditions, and the economic, social and cultural situation in the destination country. Agreements can also provide post-arrival information to workers, as in the Memoranda of Understanding signed by the Republic of Korea with several Asian countries. A key provision in agreements for ensuring protection relates to the employment contract between the worker and the employer. It should include specific information on remuneration, wage protection, conditions of work, the right to leave and rest, living conditions, dispute resolution, and social protection provisions, including maternity protection. This is especially important for domestic workers, who are often not covered by labour laws in most destination countries. The agreement should also specify that migrant workers will be fully protected by the labour and employment laws of the destination country, on par with national workers. Annexing a standard or model employment contract to the bilateral labour agreement constitutes a good practice, provided the model complies with the international human rights and labour standards. This can contribute to more equitable living and working conditions among all migrant workers, as well as between migrants and nationals. Agreements can also contain commitments by both parties to better regulate and minimise migration and recruitment costs, which can help workers avoid high debt burdens that may put them at the risk of debt bondage and other forced labour practices. Agreements should also contain specific articles to ensure easy access to complaints and dispute resolution procedures and mechanisms for access to justice in case of violations. Specific complaints mechanisms may be required in the case of violence and harassment. These provisions enable workers to seek redress for violations of their rights. Bilateral labour agreements can also ensure social protection for migrant workers by providing coverage for social security in line with national laws. Where migrant workers are excluded from national social security systems, as in Gulf Cooperation Council countries, they can specify access to healthcare and workplace accident and injury compensation as a minimum. Many agreements also contain provisions for workers to remit their savings to their families in countries of origin. In view of special problems faced by women migrant workers, especially domestic workers, bilateral labour agreements can contain general provisions which apply to all workers and specific provisions to deal with the specific situations in relation to issues such as working time, leave and rest periods, ensuring privacy and the right to communication. These may be best addressed by developing dedicated domestic worker agreements accompanied by standard employment contracts such as those annexed to the agreements with Saudi Arabia. Finally, for more complete protection, the bilateral labour agreements should cover the entire migration cycle, pre-departure, employment in destination country, and return and reintegration. Origin and destination countries share responsibility for ensuring protection of workers at each stage.